Order. The House and Committee on the Court's Remote Participation Bill is resumed. When the House lifted for the dinner adjournment, Honourable David Parker had the call.
Where is he?
He only has a few seconds, so some other member may like to take a call. The Honourable Leanne Dalziel.
Mr Chairman, I wish to challenge the government to explain to the House why this piece of legislation is being pursued in the way that it is. We had a second reading debate yesterday, and in that debate we made it very clear on this side of the House that there was only one element of this bill that was standing in the way of unanimity in terms of its passage through this House. Just one factor, and that is in relation to the use of the ABL in substantive proceedings in front of the House, where in fact an accused has the right to be present at the trial. And I made the point in my submission, and relying specifically on that occasion on the provisions of the parts of the Human Rights Commission submission, which I actually now don't have in front of me, which is why I'm struggling to refer to it. So instead of referring to the Human Rights Commission submission, which I will have to go and get a copy of, I will refer to the New Zealand Law Society submission, because they made the same point as the Human Rights Commission. And that is that this bill should have been the subject of a vet under the Bill of Rights Act, and the fact that it got through the system without having a question mark raised. Well, I don't know that the Attorney General actually took as much notice of this particular provision as he should have, and this actually is a problem, because this clearly breaches the Bill of Rights Act. The New Zealand Law Society makes that clear, as does the submission of the Human Rights Commission. And I would have thought that the submission of the Human Rights Commission would have been relatively compelling in terms of the obligations of a government, or an Attorney General in this case, to put on the table of this House a report noting the inconsistency. And there is inconsistency. The Bill of Rights Act states absolutely explicitly that there is an obligation to have an individual present in terms of being present in court. That is a right under the New Zealand Bill of Rights Act. There is an absolute obligation for the government to take heed of that. And I don't believe that we should for a minute let go of something that forms the basis of the rule of law that we believe is so fundamental to our democracy here in New Zealand, to allow for this to continue in the way that it was. I was actually incredibly disappointed that the government put this on the order paper for its committee stages today. Why would the government do that? We raised all of these issues in the second reading yesterday. I was absolutely shocked to find this down for its committee stages today, because it seemed that, I felt that the Minister was prepared to at least listen, but no, there's been no listening at all, and in fact there's been a desire to push this through suddenly. What is the urgency? Why can't we take the time to report this bill back essentially deal with what is a very fundamental issue? The government has completely ignored the submission of the Human Rights Commission, and I had a Human Rights Commission submission in my drawer and it's disappeared. So, there it is. So it's come back miraculously. It's now in front of me. I don't know how it disappeared. I think it was pirated away. But the point that the Human Rights Commission makes, and I think this is the most important thing, is that the bill does not comply with certain rights in the New Zealand Bill of Rights Act. It is incompatible with the international human rights instruments, particularly the right to a fair and public hearing and the right to be tried in the presence of and the right of the accused to defend himself in person. But the most important point, and I think this is where the Minister was actually starting to listen, is that the rights that are destroyed by this bill are those that attach to the victim. The victim has the right to confront an accused. And if Mr. Chairman, and if the accused can be able to avoid their responsibility in fronting up to the court, and the Human Rights Commission says at the first instance and then at the trial itself, there is no question in my mind that the victim is having their rights actually reduced by the government's decision to make this without consent. And so by switching the onus and by essentially saying that the Bill of Rights Act can be overruled in this way, it is simply unacceptable to this side of the House. There are two supplementary orders that have been tabled, as I understand it, to address this issue. One is in the name of, well, they don't appear to be in the name. Oh yes, one's in the name of the Honourable David Parker, the other's the Dr. Kennedy Graham. David Parker's one actually has the advantage of its simplicity. It just simply says that despite subsection 1, AVL must not be used in any criminal substantive matter for the appearance of the defendant unless the defendant consents to the use. Now that resolves all of the problems, and actually it addresses the issues that the government was raising with this bill anyway. I mean, on this side of the House we are entirely on side as far as it goes with respect to the procedural matters. Nobody objects to people not being ferried to and from the prison in order to attend to an interlocutory matter. It's not important that they're actually in the court, and if they want to see it dealt with in that way, then they can simply have the AVL link used. What I'm concerned about, and what we on this side of the House are deeply concerned about, is that there could be a fundamental breach of the Bill of Rights, and it should be purely on the basis that the defendant would consent to that use under the particular circumstances of the occasion. I think we can all think of occasions where it might be appropriate, but if you take that right away from the defendant, you will also take that right away from the accused. And I don't think that the government's actually given enough attention to the Human Rights Commission submission, which I thought had some very important points to make. Another point that the Human Rights Commission made in their submission was that the Bill of Rights Act provides rights in relation to criminal proceedings, and they are the right to be brought before a court following arrest, the right to a fair trial, the right to be present at trial, and the right to examine witnesses on an equal basis to the prosecution. What this submission says is that the Crown Law Office, in providing its advice to the attorney, unfortunately managed to conflate practices in which the evidence of witnesses can be given by AVL with that of an accused being entitled to be present and to give evidence in person. And so the Human Rights Commission has a serious challenge to the quality of the advice that was provided by the Crown Law Office, and I think that needs to be addressed by the government. Yeah. The government actually has to stand and respond to the very specific concern about the nature of the advice that was given on this matter. And I know that the Attorney-General would have to be concerned about the level of challenge that the Human Rights Commission are giving to this analysis. And the analysis itself appears to be based on a case that was determined, when was that determined? In 1990, the United States Supreme Court, Maryland and Craig, that addressed only the giving of evidence remotely by a witness by AVL, not the accused. And unfortunately, I don't think that the Attorney-General has actually appreciated the extent of the difference between the two factors. Giving evidence as a witness by AVL has